Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. There's three hosts to this show. My name's Todd Ryan. I'm one of them. The other two are David Michaels and Jeff Neuman. I'd like to start the show each week by saying hello to my co-host. Hi, David. How's everything going with you? Yeah, sounds pretty good. You got a new microphone or anything like that? Let's see if try that again. I'm checking to see how the YouTube stream is going right now. Yeah, we have problems sometimes with the YouTube stream. I'm going to restart that capture. Couldn't hear you. Okay, now try it.
All right.
Yep.
Testing. Testing, 1, 2, 3.
Yeah. So for those who listen, we have replays on X here, of course. As soon as this is done live, you can listen to a replay on X. We stream live on YouTube. So as soon as we're done, you can also listen to a replay on YouTube. And then usually the next day or a day or two after, let's make sure it's on Spotify and on Apple Podcasts. But I notice sometimes, I use OBS software to stream on YouTube, and sometimes the audio outside of my own, there's two different audio tracks, mine coming through my microphone, and then my laptop audio that comes. So when I hear David and Jeff speak, um, hear it through. Anyway, Jeff may join us, but it's like, let me see, it must be 9 o'clock, I guess, over in Gibraltar. He's participating in a lawsuit over there. He's an expert witness. Really interesting case. I'm sure he'll want to talk about it when he gets back. But he's working right now, I know, because I see some of the work he's doing. Of course, I work with Jeff now full time. JJN Solutions Law, PLLC. Okay, so we had some great news today over at the law firm, and that is one of the clients that we represented in a UDRP just won. He was a respondent that we represented, just won, and we also got a ruling of a RDNH. That decision, you can check it out if you want. I think Andrew Alleman wrote about it today. It just came out yesterday. I'm going to talk about it next week here on the show. Jeff will be back, and it's the domain was chainbridgeestates.com. Funny, it was a project, a development right near Jeff's house. I mean, pretty close there in Virginia. Anyway, so it was a business dispute, and one of the business partners wanted to take the name from the other person they were doing business with and tried to say it was, registered in bad faith, when in fact, you guys know, if you've been listening to this show, business disputes are really outside the scope of the UDRP. Those are for, court. If you have a problem, you think somebody is, there's an issue with a business contract, or if you think their former business partner is doing something by, infringing now on one of the parties' marks, it's for court. It's not for a UDRP. But we're going to see in a case today that people, entities, companies will file a UDRP to try to resolve an issue that is really outside the scope of the UDRP. We say that all the time. But a UDRP, is really for, okay, this person registered this domain name. They're targeting me. I'm the trademark owner. And there's ways I can show that they were targeting me and that they registered this name in bad faith. And that the person has to show, the complainant has to show, I have a trademark. 2, they have no legitimate use for it, or they're not using it in any legitimate fashion. They're not known by the name. And 3, they registered and are using it in bad faith. Okay, so the complainant just has to show that stuff. Anyway, pretty difficult to do. It's really impossible if you really looked at the facts when it comes to, it's a business dispute, meaning it was, they went in together, working together, and now things have changed. So the name, usually was never obviously registered in bad faith. But okay, we're going to talk about 3 different cases today that we're going to review, but 5 different cases because 2 of them are in the news that we're going to touch on. But David, I wanted to quickly say, yeah, there's always some, what is it called? Um, Controversy or drama in the domain business. So I'm not really even going to mention the name because I don't want any heat or whatever they call it from any beef with George Caricos. Okay, he owns freespeech.com. So check out his website. But he well-known domain investor. I've always known him as just a premium domain investor. Got great names, and then most people know him as he does a lot of research on finding out about big transactions that other people just haven't uncovered because we know a lot of domain name sales are not public. Well, he uncovers big sales all the time, and then what he's had a problem with really for the last several years is he'll uncover a big sale by looking through some company's financials or doing other investigative work. And then he posts this information at freespeech.com. So check out freespeech.com. Don't want to get on this bad side. Canadians. Crazy. Crazy. A lot of crazy Canadians in here. I see several, including my co host. All right. So, anyway, he reported on a name that was a big name that was sold for millions of bucks. And then all these bloggers, post, hey, here's this information, and they don't credit him, cite him or whatever you want to say. They don't give him the credit that he believes he deserves for it. And I agree. And then he gets mad and he just lashes out at some of these guys. Well, calls them parasites, which is, that's his opinion because they're taking stuff that he's researched. And and it really just, I mean, it seems like no one, I can't think of one blogger, maybe Domain Gang he likes. And then I was going to mention before I ask you a question, David. I don't even know what the question is yet. Is yeah, on our outline, dnlshow.com/outline. You can go to dnlshow.com and click outline, but you can also just /outline. I always, sometimes, yeah, I'll look through the different blogs or different websites and I look and I see, okay, like today, there's one from Domain Gang that I'm referring to. They were talking about an Agent Bay case, agentbay.io. And then Andrew Alleman wrote an article about this dentist in Orange County, California. I don't know. Okay, but so I put in there, hey, here's the title of their article. Here's the anyway the website, and here's a link. So when you're checking out our outline, click on the links and check out Domain Gang today. Check out DNW. But some people don't like that you even use their link to them sometimes, I guess. But these two have never said, Todd, don't do that. If they did, I wouldn't do it. I remember anyway. So David, before I talk about some other people that I usually don't link to anymore, yeah. So did you see, without mentioning the name, did you see George Caricos, posting and how upset he was about the parasites in this business? Just curious if you saw that.
I haven't seen any of that in over a year, mainly because I'm not on Twitter that much or X. I just don't have the time for it. I'm sleeping more.
Good. Yeah, I am getting busier too, and on the platforms less. Try to still. I mean, okay, so we're going to continue to do this forever. This domain name law show, we're going to do it forever. Um, I don't think last week or the case that Jeff I worked on with Jeff, but Jeff is he's the lead. He's the one that got us a win in this last case and RD&H. But that was a referral to Jeff, not from this show, but we do get people that reach out and say, hey, I was listening to you guys' podcast. So if you're listening to replay, and I have it on the outline, but if you have a domain dispute and you need legal help, contact JJN Solutions. You can go to jjnsolutions.com or just send an email to Jeff at jjnsolutions.com or Todd at jjnsolutions.com. No, we want to help. This is definitely, Jeff's expertise. He's also a panelist. But in addition to more more broad lawsuits, I mean, if you have a lawsuit that's related to IP or even artist management or, well, definitely the domain space, if you're suing a company in the domain space, or if a company's come after you for some reason, or you think you're treated. But that's why we do domain name law, just to talk about legal issues in the case. At the end of today's show, if you have any questions for me or David, raise your hand. Come on up. Probably get through our outline pretty fast today. Like I said, we got 5 cases. The other thing I was going to mention, so the George was mad at people. Oh, there was something else. Oh, there was a domain AAE.com that I was watching. It dropped at Namebright, and it was on Dropcatch, and I thought that thing would go for higher. I think it ended up about 55,000. If anyone knows, tell us later on, post it, or come on up here later when we get done with our stuff. You can tell us. But anyway, somebody dropped a 3-letter.com, and of course the registry.
Yeah, that sold
Yeah.
for 52,500 according to Name Bio.
Okay. I looked right on name bio after that, didn't see it, and now it's there. You say, okay, yeah, I did have it on my screen, and it said ended, and I saw it was 50,000 something, so 52. Well, David, I think that's. I mean, I don't. I think it's cheap for a 3-letter AAE, but I don't know how many other extensions it's registered in, how many companies are use those letters, but they're pretty, pretty popular, meaning pretty. Um, Seems like they'd be used. Do you think that's about right wholesale for a name like that? AAE.com, 52 grand.
I have no feel for 3-letter.coms because I don't have any and I don't watch that market, but it's not a famous brand, that's for sure. AAE.
Yeah.
I can't think of any company offhand, so
Yeah. If a
who
company
knows?
did have it, I was saying, sorry to interrupt you. If a company did have it, like a airline, I guess American Airlines is AA, so you wouldn't want to get close to them. But AAE, if you had that was your company acronym or some reason you use that, sure is inexpensive to look big on the side of a truck or airplane, anything. AAE, just people know 3-letter.coms are expensive. So to get one as an end user for that price, good. If you're a reseller, I don't know. I'm going to ask Josh on Thursday. We got a big show over there, dnxshow.com. You can see, well, I don't have the outline for this Thursday show, but anyway, that's domain investing. We're going to talk about these sales, a lot of drops lately, why I posted that I think domain investing is harder than ever. And I said from the top end to the bottom end. And what I meant by that is basically, even GoDaddy was saying that the number of sales that they're seeing on the top end has shrunk. And I said, years ago, yeah, the 5,000 and below, say $3,000 to $7,000 sales, those are going to balloon up. There's going to be so many more because companies are willing to pay, especially low 4 figures for a domain name. But I believe less are willing to pay. Um, there's so many options. Less are willing to pay high 6 figures, 7 figures. But of course, you won't hear that from the brokers. Things are better than ever. We're selling $1 million names. You guys don't even know there's 9, 10, 11, 12 fucking figure names being sold. It's so full of. But anyway, GoDaddy had said that on the top end, there's less transactions. On the bottom end, there is more transactions in the 3 and 4 figure range, but there it's just spread across more extensions than ever too. So like I said, I think it's harder to pinpoint what names are going to sell, and when you invest, you have to buy more than one. It's like being a record label. You can't just have one artist and try to hit a home run. You
You,
got to,
you know,
yeah.
I gotta say this.
Mm.
So a recent sale got reported this week was agenticCLM.com. I can't tell you how many legal tech vendors are selling CLM systems, and they all have these nondescript names that you cannot remember that make no sense, and they're multiple words that don't go together, and you just can't keep them straight. So anyways, this domain was agenticCLM.com, sold for $9,000. And I think that's well worth it because a name like that will separate that CLM provider from all the rest. Not that I need any CLM. I don't think you do, but I don't know what kind of companies need CLM. Maybe like Salesforce. I really don't know. Who uses CLM these days? I contract um, management or whatever.
I did see that sale, and those type of names so general to me. It makes me think of that Aaron who bought Agenic AI, and I think he spent like 120 grand on it. And hopefully he's just busy, like a lot of it. Sometimes you're on these apps less and less and you're not around, but it's like he's, or the flip side is sometimes people are gung ho domain investors until it's like boxing. You get hit in the nose and you realize, geez, I spent a lot of money. The sales are few and far between. Uh, Boy, I'm just going to take it easy and, still own them. Cross your fingers. Hope you make some sales. Hope you get, out of, but anyway, get into just the general names, Agenic CLM, Agenic AI. But, I, I heard, I think it was Drew Rosner saying, I haven't watched the Sherpas lately. I think I'm going to watch last week's because I think Josh was on there. But saying that, yeah, these it's really slowed up. He mentioned it in one of the recent episodes. Really slowed up these exact, these high search terms. But I was always suspect of that when people would go, this term is searched a lot on Google. This is a high. I just don't. That just never, meant much to be. Even sometimes when a company said, "Boy, there's a lot of ad spend on it." All right, well, that's better than just high search volume. But still, I'm like, all right, well, so how are you? The name there. I don't know. Just some companies just don't find the value in owning. Uh, they could be a payroll administrator, and they're not interested in payrolladministrators.com, even though it's key. I think probably own that since I'm a domainer. All right, we're going to get to our outline and start talking about what we have on there so we can get through it. Like I said, if you had any questions, when we're done, it'll be about 40 minutes, 30, 40 minutes. We'll try to get through this fast. Come on up and ask them. Okay, on our outline today, the very first case was, I put it on there, David. It was that news on Domain Gang, agentbay.io. UDRP, and we're not going to review it completely, but bottom line was Alibaba uses Agent Bay as their AI agent platform, and they launched it in 2025. The deal is they this respondent registered the name in December 2024, agentbay.io, and to summarize the UDRP decision, the panelists said, well, you didn't have a trademark for Agent Bay in 2024. You didn't get that till 2025. So this makes this case pretty simple. And those two words, Agent Bay, it's sort of generic in this space. Now, Alibaba's argument was, no, we were actually using AGB. We were actually using the term Agent Bay. I mean, internally, maybe no one knew about it, but there's a way that somebody could have deduced that we were going to use Agent Bay from agb.ai. So we still think we have rights to it. The panelists didn't agree with that. But this was basically, I brought up this case because I wanted to send you people to Domain Gang and also show that, look, these big companies, you just because you're Alibaba, it's big, you don't, file a claim and automatically, have rights to something, even though it sounds unique. Agent Bay, does that sound generic to you, David? Agentbay.io?
Yes. And I got to say, this agb.ai domain name that they said they had launched on, the Wayback Machine only shows registrar parking page with no Agent Bay branding visible on it. So anything they had was internal, and they didn't have any even nascent trademark rights to that brand. But it is generic in a lot of ways because the way agents work, they're a cluster on an AI system with a whole bunch of LLMs. And so these agents will feed off of the like a router, and it'll go out there and do stuff. And you'll have, say, 20 or 30 agents in one AI system now. And so, of course, you need a bay where they can have a hybrid memory and share all their information.
Yeah,
I don't know if that's what Alibaba's doing, but that's what it means to me.
yeah. And ever since, ever since I've used eBay for the last 30 years, but that was the first time that, and I understand what a bay is. I'm a, I'm a film editor now. So we would use that in the editing business. But really, I was getting to eBay online made the term something bay so popular that there were copycats that would use a term plus bay, and now it makes sense in the artificial intelligence industry. But okay, so anyway, Alibaba, just they're a big company, tried to get a name through a UDRP, and we're seeing this more and more. Companies know as soon as they become aware of a UDRP, they think, well, that's for me, right? So somebody's using a name that I think I should own, so I file this and I explain, yeah, this guy. But usually, sometimes the big companies think I'm bigger. They're doing something exactly like me, and they just get um, in 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 lawsuits, they always have an advantage because you've got bigger pockets and you can just, obliterate a defendant by just, making them spend a lot of money on defense. And, and, and then there's sometimes a settlement, and a complainant or like a plaintiff in a lawsuit feels like, oh, that turned out good for us. That was an okay settlement, when they might not have been able to win a case, but defendants just cannot spend like these big companies with regards to lawsuits. But anyway, um, they also think, yeah, this means absolutely nothing. Just file a UDRP. If the person doesn't answer, or if we get a panelist that just somehow loves our company, we could get a ruling in our favor, and it does happen. I don't know. We'll go through our cases today. I think there's one decision I'm not thrilled with, but the other ones seem pretty fair. The second piece of news was an article DNW wrote, and that was basically, I just liked the title of it because it sounded like, geez, in the domain business, a dentist, an affair, and reverse domain name hijacking. Geez, all in the same room. Okay, so it was basically a case where, well, David, tell the group about the case. We're not going to review the whole case, but tell them what happened here, and what, how Andrew lured us in with this title, what it all means.
So this guy lost his wife because she went to this dentist who has the same last name as him. They're both Korean, South Korean, I guess. And so the dentist and his wife got together. The husband made a gripe site. There was some litigation. There was a settlement agreement saying, hey, okay, I have to keep the site up, but I'm not going to add any more information, and we end this lawsuit. And so now the dentist is complaining, say, hey, he added more content to the website, and so it's different. So now I'm filing a UDRP. And the panel said, no, you can't do that because it's not cyber squatting to begin with. It's a gripe site. But you are trying to enforce a court order through a UDRP. That's not the way to do it. You go back to court and you say, well, he's in breach of this court order. Can you enforce it? That's what the proper procedure is. So it's outside the scope of the UDRP. Can't file one regarding something that's already been settled in court.
Yeah. So what happened there? There was guy's wife started cheating with the dentist. He went online, created a website, and I had to go to it. I forget the name of the site now, but anyway, it was something. And I went to it, and it shows pictures of the dentist. And the guy was mad. But then, like David said, so there's a court. They went to court about it, and the court already ruled. All right, so there's a website involved here. Don't put more stuff up. We're going to settle this thing. You guys all agree to this. And then, I don't know, the dentist wanted to get the site and do a UDRP action when there was already, like David said, mentioned in court. And the panelists said, no, that's already been ruled on through a court. We don't come in and correct court rulings. As a matter of fact, we're just an administrative hearing. So no. So anyway, everything stays as is. So in that case, but now let's get to our cases. I just wanted to say about DNW. Yeah. So when you go there, like I said, today's article, there's an article that shows the case that Jeff and JJN Solutions just succeeded in, and it talks about a project developer. But yeah, we're surprised Andrew right on top of it, looking at the UDRP decisions, and published the case that Jeff and I worked on, chainbridgeestates.com. And we're going to talk about that next week here on the show about some background. It was somewhat interesting. A case today really similar to it. We're going to get to the first case today. thenookshop.com is the domain name. So this is a domain registered through Cloudflare by this individual out of New York. The complainant in this case, Strobe LLC. All I know about them is they had a company called Nookmart. That's what they basically, the complainant originally operated a business called Nookmart, and they were on the domain the Nookmart, Nookmart. Like I said, the that was the complainant was on the Nookmart. The disputed domain here is thenookshop.com. But so anyway, they complainant what they did for a business. I guess they also had nookmart.com too. They had Nookmart and the Nookmart, but whatever. Their website provides entertainment services for players of Animal Crossing: New Horizons. So it's probably a really big game, Animal Crossing. Been around for years. David, have you heard of that, Animal Crossing? What is it, if you know? It's a digital game. What is it?
Yeah, it's been around since the 80s. So basically, a frog wants to skip or hop across the road and without getting run over. That's the game I remember. But I'm on the website now, and it looks like it's a little bit more advanced than that.
Oh, if that's the game, of course I remember that game. Frog jumping across the road. I didn't know that was Animal Crossing. Well, hell, that's my favorite game. Just kidding. But no, I do remember that. I was like all over the place. People understood that too. So I got to get across without. Okay. Okay. But anyway, so this company said, we're Nook Mart. We have the Nook Mart. We have Nook Mart. We're filing this complaint because this person registered thenookshop.com. The longest story short, we're going to get through these cases fast today. This complainant um, mentioned in their complaint, well, the two parties that we believe own thenookshop.com, these are two guys that used to be independent contractors, performed services for us from 2020 to recently, and or I think to recently, but anyway, they had two of these guys were independent contractors for a complainant, and that really is what lost the case for the complainant. What I mean is, yeah, the eventual ruling here by single member panelist David Miranda was the domain will remain with the respondent. So the complaint was denied. And it was for the exact reason that there was a relationship between the complainant and the respondent or respondents, and this is a business dispute. So the complainant laid it out, the respondent laid it out too, saying we had an agreement, a non-disclosure agreement with the complainant that said we were going to be working with them and so on. But bottom line is the complainant had a business agreement with the respondent. Their business arrangement changed, unhappy, and then didn't like that. They felt like they're taking business from us, which sometimes can be sort of grounds to go after if you believe they registered a name behind your back and they did it in bad faith. But in this case, there was also the respondent was using the defense that I guess apparently in this Animal Crossing game, there's a Tom Nook or Tim Nook or somebody in the name that's very popular. Nook is used a lot in other products, whether it's online products, but everything related to Animal Crossing. Nook is like a I don't know, sort of a generic word. So they use that. But basically, the panelist just said this is a business dispute. You bring it up here, but it's becoming more and more common because companies know, like we said, it's $1,500. This was at the forum, so I believe it's like $1,300 to. And I know what it is, but anyway, so it's not a large amount to file a UDRP case, and you just basically then wait and to see there's a chance we could win. In this case, the respondents got to keep the name. David, I went through that pretty fast. Just said it was a business dispute,
Yeah,
but
but
what was
I
that?
want to say a couple things
Yeah.
here. One is like the websites look pretty similar. So I think the people that left were actually the developers. And what the scope of the UDRP is for cyber squatting, clear-cut cyber squatting, not complex contractual, or employment contractor disputes. So yeah, just because they were your employee, and they knew about you and your mark, and they're copying your site, and to some extent, does not mean it's cyber squatting. It's a contractual dispute. Um, you know who they are, go after them in court. Don't file UDRP. I think that's what this case says. And I think that's refreshing change from what past panelists have done. So I hope this is a new trend. And, I think there is fair use. I thought the word Nook is um, generic for a bookshop, but I'm seeing this just video games on a website. And neither website is actually really all that robust. So it's not that big a deal. I think they're both like embryonic businesses.
It is, I guess, refreshing to see panelists say, no, this isn't for a UDRP. This isn't for this forum. I say that because some panelists feel like, hey, this is a sort of a trademark dispute, but we can still handle it here. This is an involved dispute. It's not clear-cut case of cyber squatting, which actually that we use that term clear-cut case, but nowhere when the UDRP was created or established does it say clear-cut case of cyber squatting. We've sort of evolved that on the domain owner side to say if it's not clear-cut, you know, um, but a lot of panelists do feel like, hey, I'm got this case. I'm going to decide whether, if this domain owner seems like he's up to no good, I'm going to rule against him and transfer the name to the complainant. When sometimes the domain owners are up to no good, but it's still not the proper forum. So it's like this isn't a cyber squatting case. These people may have um, reneged on a contract they had with you or something like that, and they may be doing something nefarious. Maybe they are using some of your materials that could be copyright infringement, or maybe they're, uh, using, you know, targeting you in other ways. But anyway, I like that panels are saying if it's not, this panelist just said it's a business dispute. It's not for a UDRP. So that's pretty much, if you read the response, that's why I threw it out. This next, so that was the nookshop.com, and it was ruled in favor of the domain owner. This next case, Soho House, and I got it wrong on our outline. I have sohohouse.com. It should be sohohouse.co. I'll correct that as David speaks. But anyway, I got the correct link up there. So the domain in dispute is sohohouse.co. Okay, sohohouse.com. I've always heard of it, didn't know what it was, but I guess it reminds me of like what do they call those things when people travel and it's real cheap and you can stay at like a hostel. But anyway, Soho House, I don't know if it's a classy place or not. It's out of the UK. Now it's been around for many years. They got places all over the place. Soho House here, Soho House there. Apparently they got now beds in the places, but it's more of like meeting places. I'm talking, I don't even know what it is, but I see from the complaint, I remember hearing about it, but Soho House and Co. is what they sometimes go by. So that's why they thought we have rights to sohohouse.co, a little closer than another reason why they felt like that was confusing. But David, are you familiar with Soho House, this company out of UK that's been around forever?
I'm not. When I saw the name, I thought, is this one of those Trump hotels? Because I thought he built a hotel in Soho, New York.
Yeah.
But I'm confused about that, so I don't know.
Yeah, I thought when it was New York too, but apparently, so this is a UK company that has a you know, bottom line is they have this club that's called Soho House, and it's for creatives, as it says, but founded 30 years ago, 1995, and it has all these houses across the world, spaces for drinking, dining, relaxing, working, and exercising, and many of the houses have bedrooms. So, okay, so you can imagine what it is, but the complainant is on sohohouse.com. They're on their at their website. It says Soho House and Co. So when they saw that this domain was registered in November 24th, 2024, and it resolved to a website says Soho House Insider. So it's almost like somebody that does reviews on maybe these Soho House locations or just the company in general. And they have a disclaimer at the top of the website that says unofficial and independent, not affiliated with Soho House and Co. And I went to the site and it does have a banner at the top and does have a disclaimer at the bottom. And it's basically just says, we're an independent voice of Soho House culture, um, news, analysis, legal tools for creative community. But basically, like, um, still sort of targeting, and I say targeting the community of, people that use the Soho House. And on their about page, it says, we're the unofficial guide. They would try to say that we're not related to that company. Okay. So we want to be clear about that. And also, when the respondent, when you send an email to the website, contact them, there's an automated reply that includes a non-affiliation disclaimer. So there, you would think, okay, so I have this name. Theirs doesn't. The domain is obviously not SohoHouseInsider.com. It's SohoHouse.co. So close. The complainant just felt like, hey, it's just too confusing. Even though with all these disclaimers, people that are visiting it still don't understand, because on our website we have Soho House and Co. and it just looks like it. And then the structured, robust, fair use. Yeah, and he did the current registrant, and a lot of you domain investors do this. Build a website that you're doing something you feel is whether fair use or just legal. Like we know some will create fan sites or editorial sites where they're commenting on a product, and you feel like um, that's legal, and I'm doing something that's legal. The complainant tried to use it against the respondent. The respondent, did send an email uh, as an informal response to this complaint. So it didn't, file a formal response, but did file an informal response and just said that, we're, using this. I have disclaimers all over it. I think you should find reverse domain name hijacking. I've never tried to imitate this company or anything like that. And, I was reading through the panel's decision, and first just to say, yeah, the panelists transferred it to the complainant. The panelists just felt like it's too close to have .co when they have .co on their website, or .co on their website. Um, didn't really hold much weight with those disclaimers. Just felt like it's still confusing. You're really not putting it to any good use. And one thing I noticed that they didn't like in the response, since it was an informal response, that the respondent responded with just a bunch of stuff, and it had like 8,500 words, and there's a limit, 5,000 word limit when you respond to a UDRP. And the panelist was like, they want you to respond to just the claims made by the complainant. I can tell you that's your best response. The complainant makes some claims against you, respond to just those. Don't add in any other bullshit or any other stuff you think, but this is going to help me. This tells more about me. They don't care about that. They want you to really be um, concise and just respond to the claims and provide evidence with your response. But anyway, so this person just had a big old long response, and I don't think that helped them, because they end up losing the case. And I thought they had I think if they would have had a professional help them, and it looked like the respondents are Athena Technology Consulting Limited in the UK. So it looked like they answered for themselves. I think they would have had an okay chance. But anyway, sohohouse.co was the domain that was lost by the domain owner. David, what did you see in this case that made you think good decision or bad decision?
Well, it's a bad decision because the guy was making legitimate fair use of the brand. He was an insider. They knew who he was. They actually terminated his membership last year. I think it was in December 2025. He had the name for uh, almost a year, I think, before that. He registered in 2024. And they reached out to him, and this is where it got sticky. In October, the somebody from the complainant sent over an email offering to facilitate transfer of domain names, and offering some sort of relationship. And so the respondent responds like with a price, and that was misinterpreted as price for the domain names as opposed to actual consulting. So this guy's website, if you go to it, sohohouse.co, is full of criticism. This guy is not complimentary to this company. He must have been having a horrible time with this company. He doesn't like the chatbot. He doesn't like a lot of things to do with the company. So they terminated him. They knew who he was, and yet they emailed him, and they still filed this UDRP complaint. And I don't like this panel's decision either, on the basis that, oh well, it doesn't say insider or something or sucks at the end. It just exact same trademark, and you just change the TLD. Well, that's not a rule. There are other cases where the domain has not been transferred, even if it's the exact same TLD, because it's a criticism site. And I think that this panelist, like if he was represented, he would have probably won, because you could, if you have a domain name that says like Walmart Canada sucks or Walmart USA sucks.com, having, these disclaimers all over the website plus zero revenue is the same thing or same effect as having sucks in the name. So, it's a lack of argument, poor argument, and not find the right precedents. I find that's the key thing. If you don't supply the right precedents, you're going to lose, even if a panelist normally would have actually ordered like a denial. So yeah, always hire somebody when you have a complex case like this.
I know domain owners want to, do things without legal help, basically a lawyer to represent them, and just in a hearing like this. And I've been there. I've represented myself, won some, lost some. But the panelists take it more serious when they see an attorney, and plus a domain lawyer really knows how to answer. And I believe they would have been able to maintain this domain name if they wanted. The reason why you don't get sohohousesucks.com, that's if you're going for the .com, but I was going to say that one of the reasons why you get an alternate extension is because sometimes you can get the exact word or company that you're wanting to write material about, and you have a right to it. I know people don't like to hear that. PepsiCo.co or Pepsi.co. That'd be cool, Pepsi. But they would say, oh no, PepsiCo's the name, so now adding that extension, that's a real tough one. So this .co is weird when the complainant uses co in their name. But the point is, you don't usually get, if it's an alternate extension, you're really going for that exact, mark. And especially if you plan on doing something, legal, but you just got to be, anyway, you need to really be careful. I'm just thinking it, in my head right now of, if you own taylorswift.tech, you can use that in a legal way. Obviously, there's many ways you can use it in an infringing way, in a targeting way, but there are reasons why you would get someone's exact mark with another extension, because one, it's available, and now we're seeing a lot of brands, they're not doing that protection bullshit. They have these blockers where these companies offer, here, we'll block all these extensions from you. Companies and lawyers for these brands are getting smarter, knowing that's just a cash grab, and we're not going to go out there and just buy up every other extension and start paying these fees. What we're going to do is we're going to notice when someone registers another extension in our mark and targets us and basically infringes on us, because we know most of the companies, smart companies know people do have fair use rights, to sell products, maybe sell our product, or to comment on our company. And if they feel like somebody crosses the line, then they'll handle that. But I don't know. I think companies are getting smarter about protecting themselves. I mean, they don't like to have to. I guess what I'm getting at is companies know, there's going to be people that buy our mark, put our mark in a domain name in another extension. We cannot get every variation because, if you wanted to get Soho House Sucks .tech, that's available. So, um, but anyway, panelists like to hear um, that you add a word on there. So I think if they would have had SohoHouseSucks.co, probably been able to keep this name. The panelists just felt like this was too close, and David mentioned it when the guys got on his website. I charge this much per day for my consulting services. And then when the company reached out to him, that complainant, and said, quit using our stuff. And he said, well, there's something we can work out here if you guys want to give me some money. And of course, they immediately hold that against you. Um, you know, Domain investing seems like it should be a legitimate use, but boy, it's not all panelists feel that way. Okay, that's ridiculous. But anyway, SohoHouse.co was transferred away. Like I said, with professional representation, probably could have kept that name if he thought it was worth keeping. The final case today, and if you have any questions, you want to just talk about something, we're going to be done a little early. Come up, we'll have 10 minutes to answer some questions or just talk about any domain name legal issues. Brad, I invited you up, but let us do this last case first, and then you can have your question or comment. So the last case, yeah.
Can I make a comment about that?
Sure, go ahead.
Thank you, Todd and David. Did you say, Todd, that the respondent said it should be reverse name hijacking?
Yep. The respondent did request that. And of course.
Okay, so my thought on that is that the panelist kind of took that as this person thinks they really know what they're doing. You know what I mean? And he might have copped a tood about that. Do you think that's possible?
Well, yeah, I do, Brad. I mean, if they say, yeah, you need to go after this person, well, why do you feel is it reverse domain name hijacking? If you said the reason I feel that way is because they knew about me, I put these disclaimers on when they reached out to me. You didn't want to be right, almost with kid gloves, as they say. There is a person that's judging this, right? The panelist, and when you put in these informal responses. Okay, and he sent in all sorts of, 5, 6 different times informal responses. Never wanted to do it the formal way, and the formal way is no harder than doing it the informal way. They'll send you a link and say, "Hey, do it in this, sort of this
Right.
format."
And plus, didn't you say that he wrote a 5,000 word response? So he overdid it, right? In that regard as well. So I think that the panelists, used his perception, and he made the decision that was adverse because the respondent felt that he knew too much, or was it too experienced, or whatever, but it didn't work.
Yeah, I mean, just overloaded in an informal way. Somebody's thought, listen, if you can do all this, you could have done it the appropriate way, and then you know so much. And the panelists, they know. Brad, I agree with you. I think they just didn't take it in like, oh, this guy's coming up with a lot of good arguments, and I can understand why he had to go overflow with his response. And what a great job! Listen, the panelists, from what I hear, they don't like AI responses even when they're correct. Okay, and it's okay, and I think it's great to use AI to assist you, and especially if you don't have legal representation, you want to anyway. You need very specific prompts, and you need to be very careful. But the point is, panelists take it personal when you don't. It's like going to court. If it's a civil case, you can represent yourself, but that doesn't mean, a judge is like, all right, you make mistakes, I'm going to treat you like a lawyer. Okay. So you're not going to get any special consideration. And then when you don't act like an attorney and you don't, basically respect the court in certain ways, yeah, they get upset the way you're dressed. So if you want to represent yourself, you better be very, very good at it. Okay. Extremely good at it, even in a UDRP, especially in a court case. Let me get to this last case, and then Michael will ask you for your comments, and you can go back to any other cases that we talked about. But let me get this one out of the way. The final case is luma.ai. So it's an AI name. Luma.ai is the disputed domain name. The company that filed the complaint is Luma AI Incorporated. Okay, and they're represented by some lawyers here in California. Bunch of names, 4 names in their name: Wilson, Sonsini, Goodrich, and Rosati. So that would be WSGR. Of course, they don't pay for domain names, but that would be their 4-letter acronym. So they filed it against the respondent, Simon Bernstein, who says whose name, Roy Mulia, and that's important, Roimulia, because believe it or not, he's represented out of Israel, represented by a law firm as well, said, okay, I registered this name luma.ai because it also is a combobulation of my last name. It's the letters scrambled, Mulia. And I would say, well, you're missing an A. There's an extra A. Luma. Okay. But anyway, luma.ai is the name that's, disputed. The company, Luma AI, is on lumalabs.ai. And they make, video and, basically let you go to their website and you can create videos with AI. And they've been around since, I don't know, I thought I had it down on a piece of paper, but I don't. David, do you have when they were established? Well, can you take this?
Well, they were both established
yeah.
in about 2021, but the complainant's domain was registered in June 2021, and the respondent's domain name was registered in January 2021. So it looks like the respondent was there first. The difference is that the complaint saying, well, the respondent transferred the name from himself to, or one company to another company, and therefore you get a new registration date under the UDRP, and so now we have a claim. But it's the same business. It's just he just transferred it internally because I guess he wanted to incorporate Luma Limited in Israel, and that's his business. But so he existed before they did. And yes, they're both in the same video AI business, but the niches are different. The Respond is doing stuff that's you concatenate 2 different videos, and it gives you a whole new video based upon inferences from both those first 2 videos. So the complaint is doing something more about clothing, and you try on clothing virtually. Totally different business.
Yeah, in summary, the complainant here said, "Hey, we started right at the same time this guy registered this domain name. He would have known about us. Basically, he's in the exact same business that we're in, and we've switched our name from we were never Luma Labs. That was just our website, but we were Luma AI. That's what we're known as. This person registered this AI name Luma.ai, and it's just at the basically the same time, and there's no doubt that they were aware of us. I bring that up because the panelists said, yeah, you're in America, you're in the US, he's in Israel, and Luma, it means something with regards to video. I forget the definition. Not Luma, what is it? What's the definition anyway? Illuminate. Okay, anyway, the panelists just thought, you guys both started at the same time. You say they should have known about you. I think just the opposite. How would they have known about you? And then conversely, the domain owner once again here wanted reverse domain name hijacking and said, this company. And then the panelist used the same thing on him and said, well, I'm not going to. How would they have known about you? They think you just registered the name because you heard about them. They didn't know that, in Israel that you were doing something similar. And David brought it up. Okay, this guy registered this name and he did have it for sale for a year or 2. And that's what the complainant said, and said, that's why we think it's registered in bad faith. And then this guy sent it, transferred it from his company name to his name personally, and then started building on it. So for a while, he just had it for sale. And then he's an engineer and he's decided, I think I'm going to build on this one. So with only getting a little bit of the facts and the evidence here in a UDRP, Yeah, I guess if there was, more discovery and you realized, okay, was there any additional communication? Why did this guy not want to, offer it for sale at first and then want to develop it out, which he has the right to do, but you want to know if he was doing that just to, how much did he develop it out, and was he ever targeting this company at all? You don't know really in a UDRP. You take sometimes you take both sides' word for it. Like I said, the panelists just felt like, hey, not enough evidence to know you guys even knew about each other when you're being halfway around the world. But anyway, so this panelist ruled for complaint denied that the domain owner gets to keep the domain name. And there was one other point about this thing I wanted to touch on. Well, David, so do you agree that a good decision? There wasn't reverse domain name hijacking by any means, like I mentioned. He said the complainant didn't do this in bad faith, or didn't do this to abuse the system. Really thought he was being targeted, but that isn't the case. Did you see anything else before we go to our friends?
I think it's a correct decision. The ownership history maybe is a little clouded, so it's harder to justify the refusal of the RDNH. But the complainant wasn't even incorporated until July 2021, and the domain was already registered 6 months earlier. So, there's a problem there. Like, this complainant knew that they couldn't get that name. They couldn't get luma.com, and they can't get luma.ai because it's already registered, and they could see that it's already registered. And so they go for Luma Labs.ai and incorporate as Luma AI. Well, what are they trying to do there? Were they planning on buying this name from this guy and they didn't like the price, and then decide, okay, well, we'll just go with this longer name and then go after him later when he infringes? Well, they're not infringing. He's in a different country. So, yeah, I don't think the respondent knew about the complainant, but the complainant definitely knew about the respondent all along.
So to sum up the ruling in this case, complaint denied. luma.ai was stays with the respondent, stays with the domain owner, and the domain owner, I told you, did bring up. He goes, yeah, and another thing I did, I bought that because that's my last name. It's just scrambled letters. And I was like, I don't know if the panelists bought that, but did rule on behalf of the respondent and his attorneys. Okay, Michael, nice to have you here. What question or comment did you have?
I just wanted to bring up a case that happened in the UK that went on about a name dispute like that went on for many years with a very famous band, believe it or not, who were family. You probably heard of the band UB40. Everybody's heard of UB40, of course, Red Wine, Kingston Town. But a big dispute went on between them because they broke up, they went separate ways, and Ali Campbell basically stated that he had the rights to the name UB40 because he was the songwriter and the lead singer, where the other two brothers says no, they had the rights to UB40. And this case went on for many years, and it kept being appealed and it kept being appealed. And it cost a lot of money. And in the end, none of them got it. Do you know why? Because the name UB40 was belonged to us to the social welfare system and stood for unemployment benefit desk 40. So where people used to go in the UK to collect their unemployment benefit, their desk was number 40. So they came up with the name UB40, and in the end, none of them got the rights to the name UB40, and they had to now go. They now tour separately. One just tours as UB40, the other tours as We Are UB40. But that case went on for a long time. It cost a lot of money, and none of them ended up getting it. And the government says it actually belonged to the government. It was a really strange case. That one was the way that went on, and it cost serious money. But it just goes to show you, like, anything can happen when it comes to disputes, you know.
Yeah, I remember UB40 the band. Yeah, no, I know.
Yeah.
I know a little bit about the case. Remember, it dragged on for a long time. It seemed like to me, but I didn't know how it finished. I mean, who ended up with the domain name? Matter of fact, I guess I could go to the
Yeah,
domain.
basically the courts ruled that none of them was entitled to own the name. the rights to the name UB40 because it was actually a government ban belonged to the social welfare system where unemployed people went in to collect benefits, and that's what the desk was called, unemployment benefit desk 40, counter 40, and that's where they came up with the name and created the band. And after spending all that money for so many years, none of them got the legal right to own the name.
Well, what does that have to do with the domain name itself? You know what I
No,
mean?
well, it was to do with the exact same thing. See, like there was UB40.com, obviously, but each of them were claiming the rights to own UB40.com, to own the rights to UB40 and things like that. But in the end, it was decided it doesn't make a difference who owns the .com or who owns whatever you own. The fact of the matter is, the name UB40 is belong to the government, and medias are going to get the rights of it. But that could have been decided in the beginning of the case, but yet it dragged on for a long time, costing so much money. But that was the end decision in the case, which, and I thought that was a very strange case the way that went. But
No,
I,
that's a it's very interesting thing. But my thought is that the government didn't buy the domain name, right? They didn't
no,
necessarily even know that it was a valid address. So, I mean, was it just taken away from the people because they were pissed off that the
no,
government should have got it?
No. Basically, the dispute went on between, like, so basically what happened, the dispute went on for so long, and it was costing so much money. Like, they ended up being allowed to keep the name, but none of them was actually given the official right to state that you own this name. Because when they split, they were saying we're UB40, or the main artist and the songwriter, which is Ali. He was a friend of mine for many years, when I was in the industry. But he was saying, I'm UB40, I created the band, I'm the lead singer, I wrote the songs. The others were saying, no, we are the band. There's more of us in the band. On this side, we own UB40. So it went on and went on and went on, and it was about like there was the UB40.com, the UB40. It was everything, the whole package. But in the end, it turned around and says, "Well, actually, lads, none of you actually have the official rights to own the band UB40 because we own the brand because it's belonged to the social welfare and the government body. So if you just want to go on using it, you can use it. So it's still they still are UB40." But the two of them traveled through the
Okay.
tours
Hold on,
to
Michael.
say through the
I mean,
year.
I don't know how do I say in Spanish? I don't care. I'm just kidding. I know how to say it in Spanish. No, the point is, okay, so UB40 waste. I look at the website and okay, I don't know if the government has it now or who somebody else
The
has it, but who
government, the
cares?
boat.
Okay, so it was a court dispute. We don't really know what happened, how the name. I mean, because I don't want to do any more research today. But anyway, so it's just a separate instance. You mean to bring up fucking Madonna.com and Bruce Springsteen? I appreciate it. I'm just
No.
saying
It was
no.
just.
I understand.
I just thought it was a strange
Okay,
dispute the
but
way
it
that
has
one
nothing to
happened.
do with our cases today. But no, I agree. So I thought the question, no, I'm just being rude because it's like I haven't eaten yet. It's 104. All right. Arif,
No
what did you
problem.
have to say? What's going on? Well, that's unlike Arif, huh? Not to come off mute like that. Arif, are you there?
Whoa, I didn't even know I was up. I didn't even know I came up. That's strange. So I'm in listening mode. But yeah, thanks again for the room. No, I didn't. I just came outside, so maybe I fumbled my phone or something like that. But thanks again for the good information, you guys.
Oh, no sweat. Well, we have a good show next week. Like I said, we're going to talk about a case that happened really fast. Um, Jeff handled as the respondent's attorney, as the respondent's representative, um, filled out, a great response. And then there was a supplemental filing, and Jeff responded to that supplemental filing. So it wasn't a fast case. It didn't seem like, but the decision was quick, very fast. And it was a 3-member panel as well. Interesting that, and we'll talk about it next week, so I'm not even going to give it away. But you can see a little bit about the case at dnw.com. We noticed today Andrew Alleman posted about chainbridgeestates.com. And that's how fast. So we didn't expect a decision for another couple of weeks. But boy, those panelists, and there's just no rhyme or reason to how they decide these cases so quickly. Sometimes it just takes so long. And this one was definitely, I mean, anyway, within 30 days, but also within, um, I'll have the numbers next week, but I think it was like in a week or two of when we filed the final response to the supplemental filing. But they,
Do you think that because Jeff is involved, or when there's a real high-end attorney that knows what they're doing, the panelists, want to get it right and get it over with?
well, I'm going to try to find out what day did they, assign the 3 members, because, we had a list, if you guys know how it works, both sides, when there's a 3-member panel, both sides, the complainant and respondent put together a list of 5 panelists, and then the other side can remove a couple of the names, and then what happens is the provider picks one. Okay, so here's one you picked, Jeff. Here's one the complainant picked, and then the provider assigns the presiding panelist. So the 2, complainant and respondent, get to pick the wings, if you will. But usually that takes, a couple days, because they're deciding. And then, so as soon as that was decided, everybody got the case, and they decided within a few days. I'm going to try to, it seemed like just super fast. So yeah, I don't know, maybe if they thought, they read through the response and they said, well, this is pretty cut and dry. There was a lot to it, but I did think we had a strong case, super strong case, and a super strong argument for why it should go in the respondent's favor and why there should be reverse domain name hijacking. And the panel did agree. But so we'll get into the details next week. Jeff will be back. This guy's been traveling all over the place. What is next week? Let me take a look at the schedule. Got all sorts of stuff going on next week. I'm going to see what Jeff's schedule looks like, to see if he will in fact be here next week. May 19th. Shit, looks like both of us may not even be here. We got depositions all day. So yeah, I don't know. I'll have to talk with David about what we're going to handle. Maybe we'll just handle that, because we'd like to talk about our case. And we got depositions following Tuesday too. Oh, this is a big month. But anyway, be sure to join us here next Tuesday, noon Pacific. That's 3 p.m. Eastern. Somebody will be here. And then this Thursday, would really like for all you domain investors, and really anybody, it's open to everybody, join Josh and I at 10 a.m. Pacific, 1 p.m. Eastern. That's on Thursday. We're going to talk about just domain investing inside and out. And like I posted, I think it's more difficult than ever. But we're going to talk about some recent sales, recent activity Josh has had. And just obviously, we have a lot of topics there, because anything goes on Thursday. We tried to keep it to just the legal issues here on Tuesday, but on Thursday, any domain investing topic or any domain industry topic. Sure hope you can join us and participate. That's going to do it for today. Take care of yourself wherever you're at. See you next week, but see you Thursday. Take care.
Thank you.